afternoon and welcome everyone to Kelleher and Holland's Employment Law Lunch and Learn. This is the last one of 2025. And today we're serving up employment-related new laws and amendments to current law that will be taking place in 2026. Before we dive in, I'm also proud to share that our firm was recently recognized in the 2026 Best Law Firms rankings for our work in employment law. And this honor reflects the strength of our team, two of which will be presenting today, Andy Bowling and Madeline Kelleher. So on top of new federal employment-related laws coming into play next year, in just one day, Illinois Governor J.B. Pritzker recently signed into law over 200 bills passed by the Illinois General Assembly with more than a dozen new and amended laws that create new employee rights and expand obligations for Illinois employers, most of which became effective immediately or will take effect by January 1st, 2026. So with that, we've got a lot to get through, and Madeline, I will hand it off to you to get us started.
Great. Hi, everyone. Happy holidays. Let's start with the new discrimination-related laws. There are two that are being implemented in Illinois in the new year. First, a new amendment to the Illinois Victims Economic Security and Safety Act, which will prohibit employers discharging, refusing to hire, retaliating against, or otherwise penalizing employees for using employer-provided electronic devices to record or document sexual, gender, or other acts of violence against themselves or a household family member. Employers can't revoke the device solely for this reason and must allow access to the related recordings. This will be effective January 1st, 2026. Second, there will be two new additional amendments to the Illinois Human Rights Act that apply to charges pending or filed on or after the effective date, which is again January 1st, 2026. First, it will provide that fact-finding conferences for charges under the Illinois Human Rights Act are discretionary rather than mandatory, unless both parties request one. And it adds a tiered civil penalty schedule for Illinois Human Rights Act violations, up to $16,000 for the first violation, $42,400 for the second in 5 years, and $70,000 for 2 or more in 7 years. So some pretty steep penalties coming into play. That should do it for discrimination.
Okay. Good afternoon, everybody, and thank you for joining us. Merry Christmas and Happy Hanukkah to all who are celebrating those holidays this season. We have a lot to talk about today. You know, the college football playoff starts tomorrow. There's no Illinois teams, but I can assure you this, that if we were ranking states based on the volume of new employment laws, our great state of Illinois would be given a bye in the Final Four already. But unfortunately, we don't get any awards for this. So we'll talk about just all kinds of changes, big and small, that our legislature has pushed through in the last year and that will take effect coming forward in 2026. One change, Illinois, like a few other states, gives time off for blood and organ donation. And if you have 51 or more employees, you now have to give this leave to part-time employees effective January 1. The Illinois Transportation Benefits Program Act has now been extended to cover part-time employees in addition to construction workers covered by union agreements. And Illinois, like several states, blue and purple, allows different forms of lactation accommodation and orders employers to be very generous in coming up with solutions and requests for this important need. And under the amendment to the Illinois law, employers will be required to pay employees during lactation breaks at their regular rate of pay and can no longer force the use of PTO or reduce pay during these breaks. Another law that will take effect on June 1, 2026 is to provide time off for employees whose newborn is in a neonatal intensive care unit, sometimes called a NICU by people in the medical space. And the range of time off will extend for 10 days for companies with 16 to 50 employees, or 20 days for employers with more than 50 employees. And there's also the ability to take incremental leave. We're going to break up some of the state laws to talk a bit about federal before coming back to some of the state changes. The Secure Act of 2022, the infamous Inflation Reduction Act, had a number of rules that relate to retirement plans. And one very important change for some people, particularly people age 50 and over, will now have limits on their ability to make a catch-up contribution in order to build their retirement nest egg. If you earn over $145,000, your catch-up payment can only go to Roth after-tax plans. So for some businesses, they may need to expand or create a Roth plan mechanism to allow for people above this income level. The amount of dollars, we don't know what it will be yet for 2026, but in 2025, the maximum catch-up payment is $7,500. The Mental Health Parity and Addiction Equity Act was an important law, and it was passed in 2024 with a number of complex, fiercely contested rules. And at present, the rules we are going to talk about are still in abeyance. They have been stayed due to litigation, but watch this space. Wouldn't be surprised if there is either a settlement or a definitive court ruling in 2026 that will impact these the changes to this legislation. And then there's the one big beautiful bill. There is a special mechanism for individuals who are enrolled in bronze or catastrophic level health insurance plans, which are options under the Affordable Care Act. And you will now be treated as being in a health savings account, HSA qualified, high deductible health plan, allowing HSA contributions, even if those plan options would not otherwise meet the standard high deductible health plan requirements. Direct primary care service arrangements, which provide access to certain primary care services for a fixed monthly fee, will now be compatible with HSA participation and will no longer be considered disqualifying coverage for purposes of determining HSA eligibility, as long as the membership fee does not exceed $150 per month for an individual or a maximum of $300 per month for a family, indexed for inflation. The Act also clarifies that direct primary care fees within these limits are considered qualified medical expenses that are eligible for reimbursement from a HSA or can be paid tax-free from HSAs, so long as they do not cover general anesthesia, prescription drugs other than vaccines, nor lab services not typically administered in an ambulatory primary care setting. And employers can now pair these offerings with other DPC benefits. Payroll and benefits communication should highlight eligibility rules and these caps. And finally, the annual employee dependent care FSA limits rise to $7,500 for single filers or married jointly, or $3,750 for married filing separately, not indexed for inflation. Madeline, there's some new contract-related laws, and I'll let you speak to those.
Absolutely. Two updates to Illinois law will affect how agreements are drafted, enforced, and interpreted. First, there's a new amendment to the Illinois Digital Voice and Likeness Protection Act that provides that the failure to include a reasonably specific description of the intended uses of a digital replica in contracts for the performance of personal or professional services does not render an agreement unenforceable under the Illinois Digital Voice and Likeness Protection Act, effective January 1st, 2026. Now, the bigger one is the new amendments to the Illinois Workplace Transparency Act. So the Illinois Workplace Transparency Act, we have done a prior webinar on this if you wanted to go to our YouTube page and look it up. This is the law that implements rules and restrictions on how to, and who can be subject to restrictive covenants in a contract for employment. So these new amendments will now include in the law a prohibition that, on any contract or agreement that restricts employees or former employees from engaging in concerted activities to address work-related issues. The amended law defines concerted activity as activities engaged in for the purpose of collective bargaining or other mutual aid or protection. This is very consistent with the federal law and Illinois law protections. Another amendment expands the definition of unlawful employment practices to encompass work-related communications beyond discrimination, specifically those regarding wage and hour laws, workplace safety, plus National Labor Relations Act protected concerted activities, and National Labor Relations Act prohibited unfair labor practices. Next, it will impose stricter requirements on confidentiality provisions. These are confidentiality of the agreement or confidentiality of incidents that took place rather than, non-disclosure of confidential information. So the stricter requirements for the confidentiality provisions will be in separation and settlement agreements, which will now make it significantly more difficult for employers to raise and navigate confidentiality unless employees explicitly request it on their own initiative. So the amendments expressly prohibit employers from unilaterally including language stating confidentiality is the employee's preference, which is very common practice if we were going to be using any type of confidentiality of the agreement provision. Additionally, it will require separate consideration for any such confidentiality provision contained in a separation or settlement agreement, meaning that these confidentiality provisions will now require a specific monetary amount that's separate from the other consideration that consideration exchange for release of claims or severance or other separation or settlement agreement provisions. It will also prohibit non-Illinois choice of venue or choice of law clauses, so it will be entirely governed by and within the jurisdiction of Illinois courts. It will prohibit the shortening of applicable statute of limitations periods, so statute of limitations periods for any type of restrictive covenant in the agreement will not be allowed to be shortened. And then finally, it will allow employees to recover consequential damages plus fees for violations. So that for the violations of this act. So now not only does the enforcer of the law get penalty fees, but now just any violation can subject an employer to be required to pay employees to some consequential damages. And again, this is all effective January 1st, 2026. Let's get into some training related laws. Andy? Or me, actually. I will discuss some training related laws. 3 new employee training requirements will expand employer obligations and compliance requirements. First, a new amendment to the Illinois Epinephrine Injector Act requires an anaphylaxis training program completion certificate. This creates Good Samaritan protections for authorized entities and persons, effective January 1st, 2026. Next, a new amendment to the Illinois Food Handling Regulation Enforcement Act requires food service sanitation managers to include training on celiac disease and the safe handling of gluten-free foods. Finally, a new amendment to the Illinois Lodging Services Human Trafficking Recognition Training Act will now cover restaurant and truck stop employers, and it will add additional enforcement provisions to ensure the training is provided. Again, all effective January 1st, 2026. Now, Andy, new unemployment-related laws.
Right. Thank you, Madeline. I'd like to talk briefly about what I think is going to be a very impactful change in the unemployment space for many Illinois employers. And that is they have amended the State Unemployment Act. to expand eligibility for employment benefits to individuals who cannot perform work due to a mental health disability. And this is going to, I think, expand opportunities for people to recover unemployment, but it also may make it more difficult for individuals who are fired for cause if they are able to argue successfully that the objective conduct which gave rise to a termination for cause that would disqualify eligibility was actually rooted in a mental health disability. So I think there's going to be a lot of attention and disputes and probably case law as 2026 unfolds. Also, the state gives, but the state also has given employers and taxpayers some benefits with these changes. They will provide for the recovery of unemployment benefits plus interest and penalties paid to ineligible individuals. In other words, if you fraudulently apply for and receive unemployment benefits, you might have to pay them back. It also permits courts to enjoin an employer from doing business for its willful failure to file the required new hire or wage report. So this is a lot of companies, sometimes particularly smaller businesses, view this as low priority, busy work, but now there's going to be some teeth and potential consequences if you don't do your busy work. So plan ahead. There's a new workers' rights and safety law that actually went into effect in August of 25. It's called the Illinois Workers' Rights and Safety Act. And it's limited to, really coal miner safety. So not too many coal mines around the KH offices, but this is why I think it's impactful, because this law says that because Illinois safety law borrows heavily from federal law and relies on it, it says that if there are any adverse changes to federal law that reduce the protections available to workers, that Illinois will look to the pre-2025, i.e. the pre-Trump administration rules that were in effect. And even though this covers really just a pretty small sliver of mining activity in downstate Illinois, I would not be surprised, pardon the pun, this law could be the canary in the coal mine, because there are other Illinois employment laws that rely on federal laws, such as certain components of the Illinois Wage Payment and Collection Act relies heavily on Fair Labor Standards Act decisions. And if this administration or Congress takes steps to cut back the protections under the Fair Labor Standards Act, many of us would not be surprised if Illinois says, wait, we're going to disregard federal changes made after January 25 and go back to what they perceive to be more employee-friendly protections from 2024. There's also new amendments to the Illinois Wage Payment and Collection Act that essentially makes it harder for deadbeat employers. And employers, if your company doesn't have enough money under Illinois law, the officers, directors, and shareholders of a business can be personally liable. So it essentially allows someone who doesn't satisfy an award issued by the Illinois Department of Labor, it lets them accelerate to judgment creditor status as opposed to having to go to court and perfect the judgment. So that's another arrow in the quiver of employee attorneys that they can use. If you have a child care facility, there's an important new amendment that will require increased background checks, which is a bit ironic given that Illinois has been at the forefront of trying to scale back what employers can do in terms of background checks in other areas. But if you have a child care facility, you're going to have your employees, volunteers, undergo criminal background checks at least every 5 years, not just at hire. So that will impact certain businesses. Let's go back now to the federal level, and we'll talk a bit about immigration. Now, the biggest change that employers will notice is the increased filing fee of $100,000 in order to obtain a worker under an H-1B visa. Now, H-1B visas, particularly for larger corporations, that's been a very stable and consistent pipeline, largely of STEM-trained workers. And this change, of course, aligns with the current administration's efforts to prioritize employment opportunities for what our president last night in a speech called native-born Americans, and had charts tracking unemployment rates for native-born citizens. So it's going to be very difficult for companies that have historically relied on engineering support and other very technical areas that are often, the best candidates often may not have work authorization. But that $100,000 fee is stiff and a significant increase from current levels. Also, we'll talk a bit about updates from the EEOC, the Equal Employment Opportunity Commission, which has been, somewhat quiet in comparison to a very active EEOC over the 4 years before 2025. And this is not a surprise. Typically, when a new party occupies the White House, they have a very significant thumb on the scale of what employment priorities will be, who will be making those decisions, and even selecting judicial openings. And, early in 2025, the current administration announced that DEI, diversity, equity, and inclusion programs, decision-making based on DEI considerations would be a priority for enforcement. And yes, we have seen some high-profile investigations and charges made against large employers that were quite outspoken and quite public in their support and embrace of DEI programs and participation. And I expect in October of 2025, an open spot for the commissioner was filled, and we're already starting to see some more aggressive action. A corollary of DEI is a theory of disparate impact discrimination. There's two kinds of discrimination. One is intentional. If you say, I'm not going to hire you because you're white or because you're black, that's direct intentional discrimination, and that the laws against that remain unchanged. The administration has said they will continue to enforce that form of intentional or direct discrimination. However, really since the 1960s, and as a result of case law largely, there's been a theory of disparate impact where companies can be held to account and charged with discrimination if certain policies have a disparate adverse impact on a protected characteristic. Let's assume that an employer has a test that is not job specific, but because of that test, white employees fail at a disproportionate rate to employees of other races or skin color. Well, that would be disparate impact discrimination prior to October, November of 2025, and the EEOC has already begun dismissing government filed cases alleging disparate impact. They are making some exceptions where there is a corresponding theory of direct discrimination plus disparate impact. Now, there's already been a race to the courthouse to challenge the EEOC's decision making, but it's clear that disparate impact discrimination is going to be a low priority, if a priority at all. Um, AI and employment is interesting. I mean, it was a concern under the last administration. It's a concern in many states. We've seen many blue states, New York, for example, Illinois, have said that employers that use AI in ways that tend to have disparate impact outcomes, that have an adverse effect on people in different protected categories, that's not going to be permitted. The last administration was much more vocal in warning employers to be careful using AI and to closely watch to guard against any adverse action against protected groups. We haven't heard that at the same volume, if at all, from the current administration, but we are hearing it in Illinois and again in several other blue states. In fact, there's a new law in Illinois that will go into effect January 1 that says amends the Human Rights Act that says, if you're using AI for employment decision that has the effect of discriminating based on protected classes, you can't do it. And it also bars using zip codes as a proxy for protected classes and requires employers to give special notice of their employers' use of AI. And so, kind of as a quick upshot, what should employers do? I think employers need to look carefully at their employee handbooks and see, and make sure that if they have strong DEI policies, that they are aligned with state or local laws, because some employees are looking for that. And I think, many employee handbooks that we say will state we are an affirmative action employer. Well, this administration effectively canceled at least the federal affirmative action programs, or many of them. So be careful as to what you have said historically and make sure that it still passes muster under current federal and state laws, depending on where you locate it. Madeline?
Yeah, so for more information on employment related changes in the recently passed One Big Beautiful Bill Act and the Illinois Biometric Information Privacy Act, please check out our last webinar by visiting our YouTube channel. In conclusion, given this lengthy list of expanded employee protections, Illinois employers are encouraged to review and update their policies, their procedures, and their employment agreements in both form and practice for compliance with all new requirements. Whether it be looking for help amending your policies for compliance or preparing contracts for protection, it's important for employers to obtain guidance from employment counsel with regard to these changes. And a word to the wise: be proactive. Don't wait until liability is at your doorstep to act. Kelleher and Holland LLC is well positioned to assist you in navigating the rules and requirements. Thank you very much for your attendance today.
Thank you, speakers, and thank you, attendees, for joining us today. Watch your inbox and our social media pages for details on our next webinar. So see you next year.